Welcome to today's broadcast. My name is Colleen Patterson, and I'm the Director of Employer Services and Compliance at Savoy. Joining me around the table today is one of my Savoy colleagues, Christine Guzzardo, who is a Senior Employer Services Specialist, as well as a lawyer who specializes in ERISA compliance. And I'm super excited to have her on my team. We've received countless questions around a topic that has been getting a lot of press lately, and that is the Blue Cross Blue Shield settlement. The movement has begun on the $2.7 billion Blue Cross Blue Shield antitrust settlement process. So today, Christine and we thought it would be best if we started diving in a little bit and discussing what you need to know about the settlement process, when action is needed, who may be entitled to the settlement, and more. Probably the most important item we'll discuss will be, what does this actually mean in the real world as we continue to guide our clients through their daily business activities. So, as with anything, when a topic receives a lot of attention, confusion and lots of questions are sure to follow. And this topic is no different. In order to set the stage for our discussion today, let's first begin with what the settlement is all about. So, Christine, can you kick things off for us? And would you please provide an overview of what the settlement is?
Yes, of course. Thank you, Colleen. Thank you for inviting me to join you today. You are right that it is a topic of discussion getting a lot of attention. Recently, there was a class action lawsuit brought before the courts where plaintiffs claimed that the Blue Cross Blue Shield Association and settling individual blue plans violated antitrust laws by illegally entering into an agreement not to compete with each other and to restrict competition among themselves in selling health insurance and administrative services for health insurance. So the court has not decided who is right. Instead, a settlement has been reached to avoid the risk and cost of further litigation. The Blue Cross Blue Shield Association and Blue Cross and Blue Shield companies reached an agreement to settle a legal dispute with subscribers who challenged the elements of licensing agreements. The Blue Cross Blue Shield Association has rejected any claims of wrongdoing. However, to reach a settlement, they have to agree to make some operational changes and provide payment to members of the class involved in the class action. Essentially, millions of Blue Cross Blue Shield members across the country who are or have been part of one of the 35 Blues companies impacted over the past 12 years may be entitled to a stake in a $2.7 billion antitrust settlement that was reached by these 35 Blues companies and the Blue Cross Blue Shield Association sometime last fall.
So, how widespread would you say this case actually is?
Quite. It is very widespread. When you think about the magnitude of this case, it is significant, as the 35 independent and locally operated Blue Cross Blue Shield companies deliver health insurance coverage to 1 in 3 Americans across all the 50 states, including the District of Columbia, as well as Puerto Rico.
Wow, so now I can see why there's been such an increase in attention of this case, which really is due to the recent activity by the Blue Cross Blue Shield Association and the Blue Cross and Blue Shield companies. So phase one clearly has started of the settlement process, which is really driving these questions. And phase one has been that policyholders have begun receiving notifications by mail literally this past month regarding the class action settlement. And personally, I'm covered as a participant under Independence Blue Cross Blue Shield through my husband's employer. And this past weekend, I received a postcard from the Blue Cross Association with brief information about possible steps to take. So I myself have had questions, hence the reason that Christine and I thought it would be super helpful to go through this for all of our partners today. So keeping with the topic of the settlement, let's review what the applicable class period is, who exactly is a claimant, and what the expected payouts are. So Christine, would you please address the class period and who is a claimant?
Absolutely. So the terms of the settlement provide 2 types of relief: 1, monetary relief, and 2, second blue bids. So let's look at the monetary relief component first. The settlement fund is, in the aggregate, $1.9 billion. Companies have the opportunity to share in the settlement fund if your company had one of two things. One, an administrative services agreement with a Blue Cross Blue Shield licensee between September 1st, 2015 and October 16th, 2020, or two, a group health policy between July 7th, 2008 and October 16th, 2020. So approximately 6.5% of the fund, which equates to $123.5 million, is allocated to class members with self-insured plans. And 93.5% of the fund, which equates to $1.78 billion, is allocated to class members with insured plans. So individual employees who are covered by group health plans, administered or insured by a Blue Cross Blue Shield licensee during the relevant period are also class members and have the opportunity to file their own claims. Now, the deadline to file a claim is November 5th, 2021. So next we have the second blue bids relief. The class eligible for a second blue bid is limited to companies with 5,000 or more employees that have been designated as qualified national accounts. The settlement website includes a lookup tool where you can check whether a company has been designated as a qualified national account. And the list will be updated after 2 years. In the past, only one Blue Cross Blue Shield licensee would respond to a company's RFP for administrative services, meaning a second Blue Cross Blue Shield licensee would not compete against that first licensee for the business. The settlement includes a process by which a company that has been designated as a qualified national account may request a bid from a second Blue Cross Blue Shield licensee, in addition to an initial proposal from the Blue Cross Blue Shield licensee. Second blue bids will not be available until April 1st, 2022, and possibly later. So, Colleen, would you please review who is considered an insured group or a self-funded account under the settlement?
Sure, absolutely. So this is another question that we've been getting quite a bit as well. So insured groups include both employers and other groups such as Taft-Hartley plans, multi-employer welfare arrangements, association health plans, even retiree groups, and other non-employer groups. Self-funded accounts include both employers and other groups as well. So again, those examples would be Taft-Hartley plans, multi-employer welfare arrangements, association health plans, certainly retiree groups, and any other non-employer groups. Another important point, though, when we talk about insured groups or self-funded accounts, we're really talking about plan sponsors, which means we're talking about employers. Inevitably, the next question would be, well, what is an employer's obligation to notify their employees about the settlement? Well, the settlement and the court's preliminary approval order do not obligate employers to notify employees of the settlement. Both employers and employees will receive notice of the settlement through a court-approved notice program. As I mentioned previously, I personally have already received.
Right. So, Colleen, we know that the settlement included compensating policyholders for alleged anti-competitive measures, which is the monetary relief, but it also requires the companies to amend some of their business practices and alliances with other Blues members. Would you please provide some details on what it's meant by amending those business practices?
Sure. So this really is the second blue bid relief that you've been talking about, Christine. The settlement adjusts some of the rules governing how the insurance group does its business to prevent regional territories and anti-competitive alliances from forming, while lifting requirements that Blue Cross Blue Shield's revenue come primarily from its member companies and subsidiaries. So it's a pretty significant change. The settlement ends a rule that has been followed by the Blue Cross companies that limited the share of each company's total national revenue that can come from a business that isn't under the Blue brands. This change could also increase competition among the companies if they choose to expand their non-blue lines of business in one another's geographies. So again, significant changes here. So essentially, all individuals, insured groups, and self-funded accounts that purchased or were enrolled in a plan during the applicable class period They'll also benefit from the parts of the settlement requiring the insurance companies to change these practices where they were alleged to be anti-competitive. So this is what we're calling and referring to as the second blue bid relief. So really, in a nutshell, this means that Blue Cross companies can elect to compete for business in other states beyond its traditional markets where they have enjoyed, in most cases, large market shares. This allows other Blue Cross cousin companies to compete against Blue Cross companies in their market should they choose to exercise this new rule. So, Christine, let's switch gears a little bit here and discuss the potential payout under the monetary relief component of the settlement.
Sure. Okay. So the settlement payments, of which 93.5% will go to fully insured plans, apply to those covered by certain Blue Cross Blue Shield health insurance or administrative services plans between February of 2008 and October of 2020. A separate settlement class for self-funded accounts goes from September 2015 through October of 2020. So according to the proposed plan of distribution filed with the court on March 12th, the payment for each claim for each authorized claimant in a fully insured plan will be calculated by dividing the total premiums paid by a particular plan by the total premiums paid by all authorized claimants who submit claims, and then multiplying that by the total dollars in the net settlement fund. So it sounds complex, however, the formula is rather simplistic. The formula for self-funded plans accounts does vary slightly, though.
Okay, so based on the proposed formula that you just mentioned for fully insured groups, let's go over an example. So in the real world, let's say that $10,000 in total premiums were paid by a plan. We then divide by the total premiums paid by all authorized claimants. So let's say that number is $10 billion, hypothetically. When we do that calculation, the result is going to be a decimal multiplier. So when we get that, the last thing we're going to do is multiply the decimal by the total net dollars available in the settlement fund, which, as we've talked about, is expected to be approximately $1.78 billion. So in this example, where a plan had paid $10,000 in premium, the result or the settlement payment would be $1,780. I think, though, what's important to take a look at here, though, is whatever amount of recovery the employer receives under the settlement, the employer is not required, at least at this point, to share it with any employees because the proposed plan of distribution provides the methodology for the claims administrator to use in order to make separate payments to the employer and its employees. So remember that the employer and its employees are treated as separate claimants under the settlement plan. We're going to get into this, though, a little bit more because there could be a fiduciary component under the ERISA side of things. So we're going to touch on that in just a moment. But before we do that, since we are talking about payments, Christine, how does a claimant actually get a payment?
Okay. So the first step is that they must submit a valid claim online at the Blue Cross Blue Shield settlement website or postmarked by mail no later than November 5th of 2021. You also can get claim forms at the Blue Cross Blue Shield settlement website, or you may request one by phone.
So as I was just mentioning, since we're discussing these potential payments, and Christine was going over how someone who is a claimant can actually receive a payment, there is a concern, though, from a plan sponsor's perspective, where there could be potential ERISA fiduciary issues regarding settlement payments. Christine, what should plan sponsors be aware of?
Oh, Colleen, this is an excellent question. So the settlement funds are a recovery payment as a result of the class action case. Under ERISA, any portion of the settlement proceeds that are considered to be plan assets must be used for the exclusive benefit of participants in the plan and their beneficiaries, or to cover the reasonable administrative expenses of the plan. In the long form notice provided by Blue Cross Blue Shield Association, they do address how employer-employee contribution splits will be handled in the calculation of the recovery payment. The DOL has not addressed the proper treatment of settlement proceeds with respect to this lawsuit against Blue Cross Blue Shield associations. Given the size of the settlement, We are hopeful that the Department of Labor will issue guidance on these fiduciary duty issues as the case continues through this process.
I think that's a great point too, Christine, that, I would imagine that more guidance will be coming as it continues through the courts. So you're right, with it being so big, there's going to be a lot of questions. So we certainly all have to stay tuned. So Christine, thank you so much for all of your input today and for your guidance. I know you've spent a tremendous amount of time reading through all of this information. So thank you again. So before we wrap up today, let's kind of do a recap because we've gone over a lot of information. So the first thing is the impact of the settlement is significant, as Christine has gone over, because 1 in 3 Americans are covered by one of the 35 blue plans named in the settlement. So this is a big, far reach. The employer or individual can find out if they are a claimant by completing the claim form on the Blue Cross Blue Shield settlement website. Your local Blue Cross Blue Shield representative cannot do this for them, nor do you, as a broker, have access to a list of impacted claimants. That's the purpose of the form. If employers or employees do not receive a postcard, as I had said I did personally, it doesn't mean they're not entitled to a potential settlement. Instead, they can go to the settlement website and complete the form before November 5th, 2021, which will determine their eligibility. The settlement funds are a recovery payment. Therefore, employers may have a fiduciary responsibility regarding any payments that are considered to be plan assets. And as Christine was just talking about, although it's been addressed at this point in the long form, we do expect further DOL guidance may be needed on this topic as time goes on. Employees are considered a separate claimant who could be entitled to receive their own recovery payment. So it's important for them to submit their own claim form if they feel that they are impacted by this. And then as a broker, if you have had a Blue Cross Blue Shield plan, either as an employer and you've offered it to your employees, or you personally have been covered by a Blues plan during the applicable period, you could be entitled to relief under the settlement. So definitely make sure that you go to the website and complete the claim form to find out. And then lastly, education is always an important way to shine against your competition. So make sure your Blues clients are aware of the settlement and direct them to the Blue Cross Blue Shield settlement website to learn more, including filing a claim form if they feel that they may have been impacted in some way, shape, or form by the settlement. At the end of the day, no one other than the parties involved in the suit know the terms of the suit. Speculation of information or action other than what the Blue Cross Blue Shield settlement has said or released to date is hearsay. As Christine had mentioned, the court has not made a final ruling yet on the settlement, so no one has a crystal ball showing when monetary payments will be received. And one thing's for sure is that this will continue to be a lengthy process with multiple steps along the way. The process and steps will continue to be directed by the court and executed by the 35 Blues companies named in the settlement. You can find some helpful hints regarding the Blue Cross Blue Shield settlement website in the video description below. As always, should you have any questions, please reach out to your dedicated Savoy team and continue to use the resources available on our website at savoyassociates.com. From all of us at Savoy, stay healthy and safe. Thank you for joining us today.